I'm joined by Harry Litman of the Talking Feds YouTube channel. Harry's channel's hot. Make sure you all subscribe. Harry, it's been a horrible, awful, terrible week for Donald Trump outside of the courtroom, with the surging energy of Kamala Harris now at the top of the Democratic ticket for the presidency, but also inside the courtroom. You and I are going to talk separately about a real impressive motion filed by the Manhattan district attorneys about how Donald Trump should not have absolute immunity. But one of Donald Trump's other gambits I want to talk about right now that Trump lost is he tried to get Justice Arthur Engoron to recuse himself. Just as a reminder to everybody, Justice Arthur Engoron was the judge who presided over the Attorney General's civil fraud case that Donald Trump lost, where Trump was found liable for inflating the valuations of his properties. He would give different valuations to the lenders, insurers, to the appraisers, just depending on when he wanted benefits to pay less taxes, get more loans, get favorable treatment on insurance. A judgment was entered against Donald Trump with pre and post judgment interest. It's like $500 million or something in that range. And, you know, there was this piece of news afterwards that Donald Trump tried to seize on, that there was a lawyer who, you know, dabbled in real estate law, landlord-tenant law, who had a conversation with Justice Engoron before Engoron issued the decision against Donald Trump in February. And this lawyer went on this like media tour and was bragging about, talking to Engoron. And then Donald Trump requested that Justice Engoron issue a subpoena or allow a subpoena to be issued to that lawyer. Engoron allowed that to happen because Engoron said, okay, I don't even know who this guy is really. Sure, you can get whatever documents you want. Then Donald Trump would be able to renew his motion to recuse. And then Justice Engoron, after hearing that motion to recuse, said, no, this is completely frivolous. And let me just read it to you, Harry, then I want to get your take. It's the unsolicited ex parte communication. And this is how Justice Engoron refers to this communication when he denies Donald Trump's attempt to recuse him from the case. Sometime in or about February of this year, several weeks before I issued the post-trial decision and order, at the end of the business day, I left my robing room in the courthouse at 60 Center Street and rode an elevator down the main floor. There on the outskirts of the famous rotunda, this lawyer named Bailey accosted me and started haranguing me about the executive law section 6312. He did not relay any alleged facts. Prior to that time, I considered Bailey a professional acquaintance and a distant friend. His sudden appearance and vehement speech took me aback, and I simply told him that he was wrong. He trailed after me, still droning on. As I descended the judge's stairs to the street level, I entered my vehicle without saying another word, except perhaps goodbye, and departed. For approximately 3.5 years prior to this unpleasant occurrence, starting in September 2020, I had researched Section 6312 intensely and had issued many rulings, including a preliminary injunction and summary judgment decision based on it. I certainly did not need a landlord-tenant lawyer ranting about it. I did not initiate, welcome, encourage, engage in, or learn from, much less enjoy Bailey's tirade. I did not base any part of my ruling on it, as Bailey has outlandishly, mistakenly, and defamatorily claimed. The entire 90-second incident, after 3.5 years of studying and being immersed in Section 6312, was, to use the vernacular, a nothing burger. I would have forgotten all about it by now had Bailey not attempted to burnish his reputation as someone who could influence judges, which would be unethical and possibly illegal, but of which Bailey nonetheless publicly boasts. Due to the extensive news coverage of the subject trial, passerby often recognize and confront me on the street, at parties, in parks, in restaurants, and on public transportation. Sometimes their unsolicited words are complimentary. Sometimes they are derogatory. Never do they affect my rulings. As with my forced encounter with Bailey, I feel no need to report these fleeting incidents. Defendants purport to rely on the rule that a judge may consult an expert only under certain conditions. I did not consult Bailey, and I certainly do not consider him an expert on executive law, section 6312. Harry, I'm sorry I took so much time to read it, but every one of those words there required that I say exactly what he said.
No, it's a really good point, because I want to start where you started. Like, who'd have thunk it? 2 weeks ago, Trump riding high, everything going his way, and now it's back to normal in many ways. And in particular, this is a really important point. This is the civil case with, as you say, some $500 million. The appellate division knocked down the bond, and I think they're going to affirm. There's a chance they reduce the amount. But the main thing is Trump is back to having to litigate. And Trump litigating means really crappy arguments. So this is an obvious nothing burger, just on the merits, right? A recusal would be, because somehow something, imagine what a great sort of cottage industry you could be. I'll be the guy who forces recusals. I'll just, assault judges in elevators and say something, and when they grunt back, I'll make a recusal motion out of it. So it's really of a piece with Trump as litigant, which means A, serious stuff, and B, garbage arguments. And this civil case, Ben, this survives. We've been thinking everything's murky, and everything is murky with the criminal cases, especially should he manage to win the presidency. But that doesn't, he's still a convict under New York law in the other case, and he still owes what everyone estimates would be all the cash he has in the world if he loses this one. And he's still making really lousy arguments that are alienating all the judges that he's in front of. So back to the 454 million here, he's given really a series of arguments to throw it out that really are non-starters. We can get into that or not if we want, but the basic point is what a difference a fortnight makes. And here we have again Trump, for one, having lost the spring in his step, maybe directly because Kamala Harris has a certain spring in her step, but also still in trouble, in hot water, not boiling hot, not put you in jail hot, though we may talk about the New York case where he could get sentenced, but still hot water with a lot to lose. And resorting to really nothing burgers, the king of nothing burgers as a litigant. So here it's sort of, that's of a piece with the Trump we've come to know as a litigant. It's a joke, the kinds of arguments he makes, this recusal one in particular. But the basic idea of, this Trump in legal trouble, making really crappy arguments, didn't go away. For a couple of weeks he was riding high, and that part of him was dormant, but it's back, and it stays no matter what. Even if on this one he wins the presidency, there's reason to think the criminal ones go away, but not this one. I think there's no way for him to make it disappear, and it is a pretty penny. As I said, maybe appellate division reduces it, but I think the verdict holds up. But this is Trump as litigant back to his really sort of not very persuasive tricks.
We heard over and over again on right-wing media, they tried to turn this into a really big deal. Justice Engoron taking advice from this other lawyer, and Justice Engoron said, look, we're in a system of evidence. You want to call me out for that? I will let you, Trump, subpoena that lawyer. Go for it. Subpoena this Bailey character who's out there, who wants to apparently sacrifice his reputation and legal career for 5 minutes of fleeting fame. Go subpoena him. Then there is no evidence. And then Justice Engoron does what you and I think, love about the law, which is you go to the law. I was always told a good lawyer needs to have a hard ass, because you got to sit down on your chair. You got to open up your law books. You got to look at the statute. You got to read it, and you got to say, is there any grounds for recusal or disqualification? So Justice Engoron on page 3 of 8 of the order cites the precedent-setting case, Litman v. Danske Bank, which talks about recusal, and then says, nothing here says that when some wacko shows up and sees me for 90 seconds and yells at me, I've got to recuse. Okay, let's go to the statute. It's what you always told your law clerks, Harry. What does the statute say? Read me the statute. One of the big frustrations I'm sure you and I always have with training young lawyers is they sometimes give you their feelings and you go, I don't want your feelings. Tell me what the statute says. So Justice Engoron looks at the statute, he pulls it open, looks at Judiciary Law Section 14, which talks about also with specificity what's also in Section 22 of the New York Administrative Code, Section 100.3E1, going over the requirements for disqualification. And Engoron says, nothing here says wacko yelling at me requires my disqualification. And, you know, he's very smart, Engoron, because he does it in a way that's scathing, but he also, he doesn't go and outright make a bar referral for that lawyer, but he says just enough to frankly send a message to others in the legal community that this guy's a wacko. And if some other entity wants to investigate his behavior, go for it.
Yeah, and he's got to rue the day that he did it. You're right, and I don't know, is he currying favor with Trump? This guy, but look, you're right. You want to go to the 2217, but you can also take a step back. Why do you recuse a judge? Because his or her impartiality could be questioned, roughly speaking, for one reason or another. So here are all the facts. What about this? A guy assaulting Engoron and Engoron, basically straight arming him or saying you're wrong, could possibly, which is of course consistent with the rulings he's made, could possibly make us think, oh, I think maybe he can't be impartial. When you think in those terms and of what judges do need to do and public confidence in them, and that some Trump type lay in wait as he got out of the elevator and glommed onto him and said some crap, no reasonable person would think, oh, there you go, that shows Engoron is not an honest broker. So yes, he does the code. That's the right thing to do. Hard ass is the right thing to do, but you don't need it here to know it's a nothing burger, because it just doesn't get out of the box to say that something about this says that Engoron's impartiality could be questioned.
So you've got Vice President Kamala Harris surging this week. Donald Trump learning that her poll numbers are eclipsing him. Trump is learning that J.D. Vance or Shady Vance may have been the worst VP pick ever. And now he learns that he is not getting out of a $500 million judgment. Not a bad turn of events. If you were asking Harry and I where we were last Friday versus where we are today, I'll trade you today versus last week. But remember, everybody,
in a New York minute.
But remember, everybody, it is though based on, you got to hang in there. You got to stay with it. You got to keep working every day and getting out the message. One of the ways I think you could be helpful doing that, subscribe to the Talking Feds YouTube channel. I've never seen the channel so hot as it's been over the past week to 2 weeks. All of the videos are crushing it. It's free to subscribe, so check it out. Once again, Talking Feds YouTube. Thanks, everybody, for watching. Thanks, Harry.
Thank you.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.